All right, we are recording and video streaming, so I am now calling this hearing to order, and we are on the record. My name is Andrew French, Chair of the Kansas Corporation Commission. I'll be serving as presiding officer for this hearing, and I'm joined by my fellow commissioner, Annie Keither. This is docket number 25 CONS 3245 CMSC, captioned in the matter of the application of Quito Inc. for an operator's license. We are going to begin with the entries of appearance, and we will start first with commission staff.
Good morning, Chair French. Kelsey Marsh on behalf of commission staff and the public generally.
Good morning, Mr. Marsh. And for Quito.
Chairman French, John Horst on behalf of Quito Inc.
Good morning, Mr. Horst.
Good morning.
We will now move to a recommendation on notice of today's hearing. Does staff have a recommendation regarding notice of this hearing?
Yes, on August 6, 2025, the presiding officer issued an order setting an evidentiary hearing for today's date beginning at 9 a.m. via the Zoom video conferencing platform. The presiding officer's order was properly served on the parties who are all in attendance today. Staff recommends the commission find that notice is proper and that the commission has the jurisdiction to hear this matter at this time and place.
All right, any objections to notice?
No objections, Your Honor, or
All right.
Chairman French. Sorry.
You're good either way. Hearing no objections and based on staff's recommendation, I do find that notice is proper. Commission has jurisdiction to hear this proceeding at this time and place. Now I'll move to a few preliminary matters, just our standard reminders, and then I'll discuss the procedure for the hearing. The standard reminders, again, we're conducting this over Zoom. We do know sometimes things can go wrong. So if any party has a technical issue, please just ask to go off the record. We can take a brief recess, resolve that issue, and go back on the record. Second, we do ask all of the participants today to keep your microphones off or muted when you're not scheduled to talk. If everyone would mute your cell phones, phones in your offices, other electronic devices, that would be appreciated. Third, so the parties are aware, if the commission needs to consult among ourselves for something like an evidentiary ruling, we'll go off the record. The commission will enter into what's called a Zoom breakout room to discuss, and then we'll return and go back on the record. Fourth, final reminder, just please be very careful to identify exactly what you're referring to when you're discussing pre-filed testimony, exhibits, other maybe physical documents. We should have copies of everything on hand, and we should be able to follow along as long as those identifications are clear. So with that, just to confirm, do the parties have any other preliminary matters to take up? I don't understand anything was raised at the pre-hearing conference.
Chairman French, nothing was raised at the pre-hearing conference, but I have communicated briefly with Mr. Marsh this morning, and I believe the parties are in agreement that Quito Inc. is presently in good standing with the Kansas Secretary of State's office.
Okay. Mr. Marsh, any response?
I believe that's correct, and that's something that we're planning on addressing with Ms. Borst's testimony.
Okay. All right. Sounds good. Thank you for that. All right. With that, we will move to the procedure for the hearing. We will begin with opening statements if the parties wish to make them. After opening statements, we will have the examination of witnesses. For that, we will allow a brief direct examination of the witness to introduce the testimony. Then there will be opportunity for cross-examination, and then there will be an opportunity for commissioner questions and redirect. Any further examination would just be at the direction or the discretion of the commission at that point. Following witness examination, we will allow closing statements and arrange for the filing of post-hearing briefs if the parties believe that's necessary. And then we will conclude the hearing. So let's move to opening statements. I understand the parties are going to make opening statements. We didn't establish any time limits, but I would just ask folks to be succinct and keep that in mind, but no specific limits on it. And it sounds like we are going to begin with Mr. Marsh for commission staff.
Thank you, Chair French. Today we are before you regarding an order denying application for license submitted by Quito Inc. The application was denied based on the applicant's association with several entities which are suspended with commission regulations, including McSee Oil Company, Wildcat Energy, and Thor Operating. Additionally, the applicant's past KCC license is currently suspended in 6 separate KCC dockets due to its noncompliance with those orders. The applicant cannot demonstrate that it is compliance with all requirements of Chapter 55 of the Kansas statutes annotated, all rules and regulations adopted under those requirements, and then all commission orders and enforcement agreements. Therefore, staff is going to be asking that the commission's order be affirmed. Thank you.
Thank you, Mr. Marsh. Mr. Horst, do you have an opening statement?
Very brief opening statement. We agree that the order denying license is based on asserted association of Mr. McCann with other non-compliant entities, and believe that that is a legal question for the commission to address. I don't know that there's going to be substantial dispute concerning the issues regarding unpaid penalties or MIT tests that remain to be completed, but we can address that in the testimony in further detail. Thanks.
All right. Thank you, Mr. Horst. Well, with that, we will move on to our examination of witnesses without any further ado. We will begin with commission staff. Mr. Marsh, you may call your first witness.
Thank you, Chair French. Commission staff calls Nancy Borst.
Good morning, Ms. Borst. To begin, I'll have you go off mute and please raise your right hand for me. Do you swear or affirm that the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Back to you, Mr. Marsh.
Thank you. Please state your full name for the record.
Nancy D. Borst.
Ms. Borst, by whom and in what capacity are you employed?
I'm employed by the Conservation Division of the Kansas Corporation Commission.
Are you the same Nancy Borst who caused to be filed in this docket direct testimony consisting of 6 pages on June 2nd, 2025, and rebuttal testimony consisting of 3 pages on July 14th, 2025?
I am.
Do you have any corrections to make to your testimony?
Yes, at the time the testimony was submitted, it was accurate. However, since that time, Keto Inc. has rectified its corporate status with the Kansas Secretary of State. That is referenced in both of my testimonies. In my direct testimony on page 3, lines 5 through 11, and in my rebuttal testimony, page 3, lines 9 and 10, now would no longer be accurate as stated in my testimony.
Thank you. Do you have any other corrections to make to your testimony?
I do not.
Okay. Do you swear the answers contained in your pre-filed testimony are true to the best of your knowledge, given the corrections you just mentioned?
Yes.
Okay. At this time, staff moves for Ms. Nancy Borst's pre-filed direct and rebuttal testimony to be admitted into the formal record.
No objection.
All right, the testimony, reference testimonies will be admitted.
Thank you. Staff tenders the witness for cross-examination.
All right, Mr. Horst, you may proceed. Do you have cross-examination of this witness?
Very brief. Ms. Borst, in your pre-filed testimony of June 2, 2025, you discuss Mark McCann's substantial relationship with other entities, including McSee Oil Company, Inc., Wildcat Energy, Inc., and Thor Operating, Inc. Do you agree that the existence of any such relationship or association involves a legal issue concerning the correct interpretation of KSA 55-155 and KAR 82-3-120?
I'm not an attorney, so I can't answer a legal question.
So on those legal questions, do you defer to legal staff's interpretation of the statute and regulation?
I do.
Okay. I think that's all the questions I have of this witness.
All right, thank you, Mr. Horst. We'll move to commissioner questions. Commissioner Keither, do you have any questions for Ms. Borst? You're on mute.
Just a general concern that Keto is still out of compliance on all several issues.
That's correct. There are 6 dockets in which Keto is suspended, and they owe a substantial amount of fines.
Fine. Yeah, okay, great. Just wanted to reassure myself. Thank you.
Ms. Borst, kind of the same question from me. I think your testimony references that there are a number of fines, or several fines and several dockets. Would you have the documentation readily available to tell us exactly which fines haven't been paid, or is that something you would need to go reference some materials to find out?
No, I have it right in front of me.
Could you just for the sake of making the record clear, which fines have yet to be paid?
In docket 25 CONS 3092 CPEN, which is a violation of 823-408, Keto owes a fine of $2,000. In docket 25 CONS 3168 CPEN, which is a violation of 823-407G, Keto owes $4,000. In docket 25 CONS 3200 CPEN, which is also a violation of 823-407G, Keto owes $3,000. In docket 25 CONS 3230 CPEN, which is another violation of 823-407G, Keto owes $1,000. In docket 25 CONS 3267 CPEN, which again is another violation of 823-407G, Keto owes $1,000. And in 24 CONS 3072 CPEN, which stems from an 823-120 violation, Keto owes $5,500. That totals $16,500.
You saved me. I was trying to do a little math there. So we've got a grand total of 6 violations, and you said $16,500. Is that
Correct.
okay? All right. I don't believe I had any other questions for you. I do appreciate that additional information. All right. Any other questions from commissioners? Commissioner Keither, you don't have any follow-on questions? I caught you mid-drink. All right. If there are no further commissioner questions, we will move to redirect. Mr. Marsh, any need for redirect?
No need, Chair French.
Okay. All right. Well, with that, Ms. Borst, I think we have concluded your testimony today. We thank you for your testimony, and you may step down.
Thank you.
All right, Mr. Marsh, you may call your next witness.
Thank you. Commission staff calls Dwayne Sims.
All right, good morning, Mr. Sims. Please raise your right hand for me. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Back to you, Mr. Marsh.
Thank you. Please state your full name for the record.
Dwayne A. Sims.
Mr. Sims, by whom and what capacity are you employed?
I am employed by the Conservation Division of the Kansas Corporation Commission in District 3 as the manager of the UIC, their underground injection control program, and environmental compliance regulatory specialist.
Are you the same Dwayne Sims who caused to be filed in this docket rebuttal testimony consisting of 5 pages and 2 exhibits on July 14th, 2025?
I am.
Do you have any corrections to make to your testimony?
No.
Do you swear the answers contained in your pre-file testimony are true to the best of your knowledge?
I do.
Thank you. At this time, staff moves for the admission of Mr. Dwayne Sims' pre-file rebuttal testimony and exhibits into the formal record.
No objection.
All right, hearing no objection, the referenced testimony and exhibits will be admitted.
Thank you. Staff tenders a witness for cross-examination.
All right, Mr. Horst, any cross-examination?
No cross-examination of this witness.
Okay. We will move to commissioner questions. Commissioner Keither, do you have any questions for Mr. Sims?
I do not.
Just a quick question from me, Mr. Sims. Good morning.
Good morning.
You've obviously got your testimony and you've seen Ms. Borsch's testimony. You heard her detail the outstanding fines and violations and fines that have not been paid. Just for the record, is it your opinion that Keto is currently in compliance with all commission regulations and orders?
No, it is not.
Okay. All right. I believe that's all I have for you. Mr. Marsh, any need for redirect?
No need for redirect, Chair French.
All right. With that, Mr. Sims, you may step down.
Thank you, sir.
All right. We have completed staff's 2 witnesses, and we will move to operator. Mr. Horst, you may call your witness.
Call Mark McCann.
Good morning, Mr. McCann. If you're able to go off of mute for me, if you can hit the audio button. Maybe John can prompt. Oh, there we go.
I think I've got it.
Yep, I hear you now. All
Can
right,
you hear me?
I do hear you loud and clear. If you will please raise your right hand for me. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. Mr. Horst, you may proceed.
Will you please state your full name for the record?
Mark W. McCann.
And Mr. McCann, are you the same person who caused to be filed pre-filed direct and rebuttal testimony in this matter on June 30, 2025?
Yes,
Have you had an opportunity to review your pre-filed direct and rebuttal testimony?
I have not. I have not been able to review it.
And why is that?
Absence of time, and yes, I have not. I have not reviewed it.
Okay. To the best of your knowledge, is it still correct and accurate?
I believe it's correct and accurate.
Okay.
To the best of my knowledge.
You're not aware of any corrections that you want to make to the pre-filed testimony at this time?
Well, I haven't looked at it since it was submitted, and subject to that reservation, I believe it was correct at that time.
Okay. With that, we would tender the witness or offer his pre-filed testimony into the record. Excuse me.
Any objection, Mr. Marsh?
No objections.
All right, hearing no objections, the reference testimony will be admitted.
We would then tender the witness for cross-examination.
All right, Mr. Marsh, any cross-examination?
I do not have any cross-examination.
All right, we will then move to commissioner questions. Commissioner Keither, any questions?
Yeah, I just want to make sure in Mr. McCann's testimony, it says Keto lacks the necessary funds to plug the wells of its well inventory. Is that still the case, Mr. McCann?
Could you repeat that question, please?
On page 6 of your testimony, you state that Keto lacks the necessary funds to plug the wells on its well inventory. Is that still the case?
Well, on our well inventory, we are, the majority of the wells are wells that are either TA'd currently or wells that just need to be put back into production. And so lacking funding, if there are some other wells that need to be plugged, I'm not familiar with any specific orders to plug anything on our list, on our inventory list.
Okay. I just wanted to double check because that's a very firm statement in your testimony. To come into compliance with the wells that were mentioned and the amount of money that's owed, are you able to pay that?
Yes. If we can get reinstated, I will promptly cause the fines to be paid and work towards compliance at all points.
Okay, thank you.
All right. I guess I just have a quick question again along the same lines. I'm looking at your testimony, pages 8 and 9, where you just lay out your position, just like you basically just did, that you wish to work to get in compliance. Just want to make sure I understand it clearly for the record. It is your position that Keto is not currently in compliance, but your position is that you wish to work to get into compliance. Is that correct?
If I could, please. It's confusing. I believe Keto is in compliance across the board. The only thing we have is we have a handful of TAs that were denied that we're trying to discuss that when we were shut down, with the exception of those TAs. And of course, there's these MIT tests, but those were all scheduled to occur, and the KCC stopped that progress. But now they're in agreement to let us go ahead and have a licensed operator perform those MIT tests. So our intention would be to perform the MIT test promptly and to pay the fines promptly, and then address any other issues that exist. But all I'm aware of is these no more than probably 8 to 10 TAs that are outstanding. They gave us a list of quite a while back of things that needed to be done. A little over $200,000 was invested trying to comply with that list, and I believe that we have substantially complied with it. The TAs that we are discussing. So what I'd like to do is pay the fines and pay the get the MIT test accomplished, and then further address the TAs that got stopped in mid-process. And with those TA wells, obviously we'll either have to pump them, plug them, or achieve TA status by doing casing integrity test. And I understand those parameters fully, and that's our intention. We'd like to get back to business and do things correct.
Well, let me circle. I understand it is complicated and there are a lot of moving parts, but until that list is covered and until the fines are paid, you would agree that Keto is not in compliance until that is all completed, correct?
Sir, if I may, that's two separate things. One is paying the fines. The other is the original list. I believe we completed every concern on the original list. And I've already mentioned we'll pay the fines if we can get going. But as far as anything outstanding that's in violation, I'm not aware of anything that's in violation. We didn't get the standard notice of violation letters giving me exact definitions of what was needed and a time frame to accomplish them. We received a master list that we addressed. From the day I found out about that, we went to work on it with every available spare moment we had, trying to address all of those issues. And I believe we have addressed those issues.
Okay. All right. I don't believe I have any further questions. Mr. Horston, you redirect.
Mr. McCann, can you address how the issue of association of Quito or yourself with other non-compliant entities factors into your decision-making process on paying the penalties and performing the other tasks necessary to achieve compliance?
The other entities that have been mentioned today, I have only one of these I've ever had any involvement with. They mentioned Wildcat Energy. I've never owned any stock in Wildcat Energy or any involvement with ownership of Wildcat Energy at all. And speaking of myself personally, concerning Thor, I have no ownership there, nor involvement with Thor, except for the fact that we wanted to hire Thor to operate wells for us. Concerning McSee Oil Company, that company, I believe, was terminated 25 or 6 years ago. And along those years, I also, when we disbanded McSee, I filed for personal bankruptcy at that time. And I was the owner. There was no corporate entity left. I was the owner personally of these assets or liabilities of McSee at that time. And we noticed my personal bankruptcy, the KCC was noticed of that. And so in my mind, McSee is a distant memory of an entity that has failed and has been absolved of any responsibility to anyone via the bankruptcy. So in my mind, McSee's off the plate. And although we were trying to cooperate with Mr. Marsh, and he had, if I'm recalling, 4 wells that were on McSee's license that he had asked us to plug. That's recently, not back many, many years ago, but recently, last year or two. So our thought process was, hey, if we can plug a few wells and appease them, then even though we're not legally responsible, perhaps that would be our best course. So from that, I endeavored to locate those wells. I didn't want to go on the property to plug them. You know, they're not all on one property. I didn't want to just roll in there and start plugging the well. So I contacted the landowner on the first well, which was on the, at least formerly known as the Austin. He had no familiarity with that well. Then on another lease called the Folk, F-O-C-H-T, I contacted the current owner of that lease and asked him informed him, we're going to come in and plug this well. Want to make sure that you're okay with that. And he said, no, I'd like to have that well. And I sent him the location of where it was at. He reported it could not be found. At this point, I contacted Dwayne Sims at Chanute, and I told him what I've just told you now. He said, oh, those wells have been plugged a long time ago, and they were done with Kansas fee funds. And so at that point, I reported that to Mr. Horst, and he interacted with Mr. Marsh about those issues, I'm assuming. But anyhow, the point is, McSee, we have no ties to McSee. That's been severed. And from the standpoint of wells to plug, not able to locate the wells that were identified at that time. Did I answer the question?
I think so. I was actually asking you to focus on how the economics of these associated entities interact with the payment of penalties and completion of the other work necessary.
Well, the economics of these 3 businesses, is that the question? Or no?
I guess you're not understanding. That's okay. That's
try again. I'll catch it.
Questions of this witness.
because economics are a factor. Yes.
Yeah, I was going to ask how this was within the scope of the questions that I had asked, because I don't think
Yes.
Mr. Marsh had asked any questions. So um, I think we will leave it there if you've got no more redirect. Um, I think I do actually have a legal question for counsel, but I think we'll let Mr. McCann step down first to avoid any confusion here, and then we'll move on. So, Mr. McCann, we do thank you for your testimony today. Looks like there is no more further examination for you, so you may step down.
Thank you.
Thank you. All right. With that, we have come to the conclusion of all the witnesses. I think just briefly, more from a legal standpoint, and perhaps this was going to be addressed in closing, but I just want to be very clear. Mr. Horst, I guess I want to ask you the same question I asked Mr. McCann, um, and just ask you whether, from a legal perspective, is Keto in compliance with all commission orders and regulations today? And if not, why should that not be grounds for denial?
I don't believe that Keto is in compliance today with all commission orders and regulations. The dilemma that Keto is presently in is that it, as Mr. McCann has testified, it has the ability to pay the penalties and to complete the MITs and other work necessary to achieve compliance, but it makes no economic sense to do that if a license is not going to be issued due to its association with other entities. That's the bottom line, Chairman French.
Okay. Thank you, Mr. Horst. All right. Well, seeing as we are at the conclusion of witness examination, we will go ahead and move straight on to closing statements. And Mr. Horst, I believe let you get a head start on yours, but why don't we go ahead and allow for closing statements? If you have anything further, I will let you begin, Mr. Horst.
Well, I think that is my closing statement. Mr. McCann had asked that he'd be given an opportunity to speak to me before we close the hearing. I would ask for a couple
Certainly.
minutes breakout room before we complete the hearing, but
Yeah.
otherwise I don't have anything further to add at this time.
Let's before we move to closing statements, let's take a brief break. And Sean or Michelle, would you be able to send John and Mark to a breakout room?
Yes.
All right. Well, then we are going to go into recess for, why don't we take 12 minutes? Just because I don't know, or are you Mr.
We're in the
Horst
same,
and McCann? Oh,
we're in
you're
the
in the
same
same
office.
room.
We can just
All
meet.
right. If you both just go on mute, make sure you go on mute, turn your cameras off. We'll go into recess until 9:45. We'll take 12 minutes and then we'll come back for closing statements. So at this point, we are off the record and in recess, and we will return at 9:45. All right, I have 9:45, so the evidentiary hearing is reconvened. We are back on the record, and I believe we are ready for closing statements at this time. As I indicated before, we will start with Mr. Horst, if you have a further statement.
Just a brief closing statement, Chairman French. The issue of associated entities has been one that has been pending since the outset when Quito's license was non-renewed. The issue was not addressed at that time. It remains pending, and as indicated in previous testimony and arguments, it doesn't make a lot of sense for Quito to pay the current penalties and bring itself into compliance if its license is not going to be issued due to associated entities. Thank you.
All right, thank you, Mr. Horst. Mr. Marsh.
Thank you, Chair French. As I indicated in my opening statement, the applicant cannot demonstrate that it is in compliance with all requirements of Chapter 55 of the Kansas statutes annotated, all rules and regulations adopted based on those requirements, and all commission orders and enforcement agreements based on its suspensions and substantial connection to suspended entities. Additionally, during his testimony today, Mr. McCann talked about being individually responsible for mixing oils, debts, and unplugged wells. And I think, based off that testimony, it'd be an indication that, hey, he needs to address those unplugged wells before he could obtain a license, beyond just the suspensions that are incurring Quito. And then obviously there's the other entities that he appears to be substantially associated with that are out of compliance. Based off the testimony that's been provided, staff is going to recommend that the commission's order denying the license application of Quito Inc. be affirmed. Thank you.
Thank you, Mr. Marsh. I understand at the August 18th pre-hearing conference, the parties did not anticipate requesting post-hearing briefing. I'm going to assume, given the limited issues in this case, that there is no request for briefing.
Not from staff.
There's no request for briefing from Quito Inc. The associated entities matter has been fully briefed in the prior docket on non-renewal of Quito's license.
Could you give us the docket number for the record if you have that?
I think that previous docket was 22 CONS 3115 CMSC.
I believe that's correct.
Okay. We will take administrative notice of that docket, as we can freely take notice of our own files and records, and we will take notice of that docket.
Thank you.
With that, we will not order any additional briefing. Are there any other final matters the parties believe we need to take up at this time before we conclude the hearing?
Nothing else then.
All right. Hearing none. We will go ahead and close the record and close the hearing at this time. We do thank everybody for your time, and we thank all the witnesses for your testimony today. This does conclude our hearing in this docket, and we are adjourned. Thank you.
Thank you, Chair French. Thank you, Commissioner Keither.